Hi, Jan. How are you doing today?
Good. How are you?
Good. How have things been since I last saw you?
You know, as rough as it's been, but I'm getting a little better, going to therapy for my back, so it's been getting better.
Good. Well, have any circumstances changed since last time I talked to you?
No, I'm still waiting to sort of find out where we're at, and like I said, I've been going to the therapy, but other than that, nothing's really changed.
Okay. Well, I have some circumstances I want to update you on.
Okay.
So, opposing counsel has indicated to me that they're going to file something called a motion for summary judgment, which I know that you don't exactly know what that is, so we're going to go over that.
Okay, good.
But I want to mention that's a real concern to me.
Okay.
So, motion for summary judgment is a legal proceeding that happens before we even go to trial.
Okay.
And the other party files a motion and asks for the judge to rule in the case before it even goes to trial.
All right, so they're just asking him to rule in their favor?
Yes, exactly.
Okay.
And since trial is all about, as we talked about, facts, figuring out what happened, they're going to argue there are no facts to resolve under something called the open and obvious policy, which I'm going to kind of explain.
Okay.
And they're going to say there's no facts to resolve under this policy, and therefore they shouldn't be liable.
What do you mean, no facts to resolve?
Yeah, so under the open and obvious policy, if there's a hazard, let's say a pothole, and it's kind of open and it's not really hidden at all, and someone falls in it or sprains their ankle and they're injured, under that policy, the law holds that the property owner where that pothole is located would not be held liable.
Okay.
So they're going to use that policy to say that facts in our case are similar to that, and therefore they should not be held liable as well.
Okay, but a pothole's different than a spill in a grocery store.
Definitely, and that's what we're going to argue. We're going to say, you know, you were in the aisle just a little short time. It was a dirty place. You had said you'd seen spots and stains.
Mm-hmm.
And we're going to talk about how it was a small commotion. It wasn't loud. You didn't hear hardly anything.
Exactly.
But the other side is going to come back and say they've taken depositions of other shoppers. They heard a loud noise, that they saw the spill. And I think they're going to argue, since the spill was orange instead of clear, that it was more open and obvious in their view.
But how can they argue that if I didn't see it?
So that's where I think we're going to just really fight it out. Now, I will have to say, what concerns me about this is, while we have good arguments, I've looked at case law. And the case law says when the judge decides on a summary judgment motion, they have to look at case law as well. So I've looked at this case law a little bit.
Okay.
And when he's deciding, he or she is deciding, the judge, whether or not to apply the open and obvious policy or doctrine, they are going to look at the case law, and a lot of it has similar fact patterns, or the plaintiffs have similar injuries and circumstances very similar to you.
Okay.
And in those cases, the judge has thrown out the case, and the plaintiff or the injured person hasn't gotten anything.
So they get nothing?
They got nothing.
Oh, okay.
Which I know is really hard for you to hear.
Yeah, I thought that we had a pretty good case.
Yeah, and I think that's the hard part, is the judge is bound by case law. And since we're looking at it right now and kind of seeing our odds, this what makes me really nervous about them filing this. And I would say, based on what I'm seeing, we have about a 70% chance of losing the case on summary judgment.
Wow. I'm shocked to hear that.
Yeah.
And I just really thought that, I slipped on their grocery store.
Mm-hmm.
They didn't clean up the spill. It should be their fault. I thought it was that simple,
Yeah.
So it just really sucks that it's just not turning out that way.
Yeah. Now, the other thing I want to talk to you about, though, is that they have talked about settlement.
Okay.
And with the summary judgment now being something that's on the table, I think we should really talk about those options today.
So we can settle before they file this judgment summary thing?
Exactly.
Okay. So what does that mean?
So they have offered to settle between $40,000 and $50,000.
It's not really as much as I was hoping for.
Yeah. And I know that originally you had that other number in your head of the $2,500 or $25,000, $100,000.
Yeah.
But we never had it. It was something that, if everything went perfectly, we would hopefully have had that money. But what we have now is you've paid a lot of out-of-pocket expenses.
Yeah, I have.
About, $20,000 for lost work and PT and cleaning stuff.
Mm-hmm.
And so that's about $23,000 that you've had to incur. And
Yes.
that 40,000 to 50,000 would cover that right now, instead of potentially then losing on summary judgment and not getting anything.
I mean, that makes sense. Yeah, I guess it's not as much as I wanted, but it's better than nothing.
Yeah.
I was kind of hoping for more of like that $200,000 range.
Yeah.
But I mean, if you're looking at that or nothing, obviously 40 is better. It's just, is there any way we could get higher than 40, like 60 or 75?
And I mean, that's our next step, is we're going to negotiate. Really going to negotiate
Okay.
what you've had to pay out, your injuries, your PT, all that stuff. And so that's going to be the next step. I've worked with this attorney before, and I think there's a good chance we can definitely get him up from 40,000. What that would be, I'm not sure right at this point, but he tends to hit a little lower than he'll
Okay.
actually give out from his client.
So more like 50 maybe at least?
Possibly, yeah. And I think that we should try to remember at least that your expenses are our main thing, is we want those to get covered because you've already had to incur a lot of stuff.
Right, exactly. Okay. Well, I mean, that doesn't sound like a horrible option. Are there any other options, or that's pretty much it?
Well, there's always, we could try to go against the summary judgment, but like I've said, there's a lot of concerns with that, and I know that your main issue is, getting your costs covered. Now, I know you mentioned that I think it's hard for you, this idea of not being able to have your day in court.
Right. I mean, they did something wrong. They left something out there, and someone could have gotten hurt even worse than me. So it's not, I mean, I want the money, yeah, but it's not even just about the money. They should be punished for doing what they did.
Yeah.
So I'm afraid that if we do this little deal, then they're not going to have any sort of punishment.
And I want to remind you, though, this will be on public record. This lawsuit will be on public record. People will be on notice that you fought against them, that you did something, you didn't just let them stand by and let you be hurt.
Okay.
And so I think it's important to remember that you've put them on notice, and they've got to change. They can't handle these kind of lawsuits a lot. You've put them to the point where you got to change something because you're hurting people. And so not only will it put them on notice, but it will also cover your costs, which I think are two really important things to you.
Yeah, so if you were in my position, what would you do?
I would really consider settlement at this point.
Okay. And so what does that look like, that process of settlement?
Yeah, so we're going to meet with the attorney, or more I am in the beginning, kind of get a range of, where they're heading, what factors are important to them is why they're giving a certain number. I think me and you should go over, kind of where your costs are, all the ones paid, and then ones to come.
What sort of costs are to come?
Just like your continuing PT, what you might continue to have to pay for, and what your insurance doesn't cover.
Okay.
So I think we'll sit down and kind of make a list what our expenses we think should be, and then we're going to try to negotiate this out with them at a little bit of a later date.
And how long do you think that's going to take?
Not quite sure, but if we decide today, that that's the route you want to take, then I'll contact opposing counsel and we'll kind of get that process started, and I can give you a better idea.
So do I have to decide today, or?
You can go home and think about it for a little bit. I'll send you a memo with that decision tree we kind of went over earlier, kind of the options and why I'm basing my, advice kind of on settling.
Right.
So.
Okay, well, I probably want to have a day or two to think about it and really decide what I want to do, but it seems like settlement is probably the best option to get a guaranteed something rather than who knows what will happen.
Yeah. Okay, well, let me know if you have any questions, and as always, you're free to call me.
Okay,
all right.
Sounds good.
Bye, Jan.
Bye.